Welcome to our 11th online Untouchables expert talk. My name is Emmanuelle van Houdenhoven-Collard, and I am the Sales and Recruitment Manager at Untouchables, together with my colleague Marianne Stoit. Our experts today have been long-standing partners of our agency over the years. And as a matter of fact, last year, I was honored to be their guest and talk about diversity and inclusion in the Netherlands through our Untouchables eyes, as well as HR trends during the pandemic. Today, I am the one who has the pleasure of welcoming them both, Michel Mayen and Alain Camonier from Palace Advocaten, Palace Attorneys at Law, an employment law firm. Palace is in fact a boutique law firm based in Amsterdam and Rotterdam that specializes in international employment law and workers' participation law. Michelle is a senior attorney at Palace. Welcome, Michelle. She joined Alain there in 2014. She's based at the Rotterdam office. And aside from advisory and litigation expertise in the fields of, for example, employment contracts, collective company policies, and dismissal law, to name a few, she regularly contributes to the Dutch magazine HR Rendement and other law publications, notably around the topic of international employment law. Alain is, of course, also a regular contributor to a multitude of daily newspapers and professional employment law publications. He founded Palace Advocaten in 2008 and is the joint owner of the firm. He is himself based in Amsterdam. And next to his work as an attorney, Alain teaches international employment law and workers' participation law at various schools, including Erasmus University in Rotterdam. That's for my presentation, my introduction of our experts today. As you know, our expert talks themes typically reflect our clients' employment topics of that particular moment, and today will be no exception. In the current war on talent employment context, many employers are innovating to boost their EVP, employer value proposition, in order to either attract and or retain employees. Michelle will start by giving her insights on the subject, as well as some valuable tips for employers. And she will also share which modifications you may need to bring to your template employment agreement in order to be compliant with the new European Directive on transparent and predictable working conditions in the EU as of August 1st, 2022. Alain will then take over and make the link to our previous expert talk with my colleague Marianne and our partner Interfisk back in December, for those of you who were there as well. Cross-border remote working seems to extend itself further in Europe and of course beyond. And as an employer, what do you need to put in place to make sure that, for example, your international employee can keep working remotely post-COVID for your Dutch company? What are the legal risks? How can you best prepare for example, a remote sickness or remote resignation? And last but not least, and because also it has been definitely many and numerous inquiries from our clients on the subject, Alain will give us the latest on the work permit situation in the Netherlands for newly arrived Ukrainian refugees. And before I give you a quick run of our session, you can see the detail here. I will actually stop sharing my screen so that Michelle can start her presentation there. And then if I manage to do so, which would be nice. Yes. So should be okay for you, Michelle. So the webinar, as always, will last about an hour. Well, it will last 1 hour. 5 to 10 minutes will be left at the end of Michelle's and Alain's presentation for a Q&A session. I will be monitoring your comments and or questions in the chat or in the Q&A and during that time, and share them with our experts during the webinar, if it's possible, or at the end of it. So if your question is not mentioned, no worries, we'll tackle it at the end of it. And again, thank you for joining. And Michelle, it's all to you.
Thank you, Emmanuel, for the introduction and for having us here this morning. And to all participants, welcome. Alain and I are going to talk to you today about the post-COVID Dutch and European employment law trends and necessities. We say post-COVID, of course, COVID is not yet entirely gone, but society is going back to normal a little bit more, at least with regard to COVID. And also the working from home advice in the Netherlands has been released. So we are seeing in practice that people are returning more to the office. And what we'd like to talk to you about today is how to deal with this new post-COVID period in terms of employment law. It's not going to the... yeah. So what I would like to start with is talk about hiring and retention of staff while also maintaining flexibility. The latter, I think, is important because, of course, it remains an uncertain situation that we are in. At least for now, we are returning back to normal, but we never know if in a few months from now, we might be in an entirely new situation where your requirements for staff may also already have changed in the meantime. And therefore, it's still a good thing to keep as much as possible certain flexibility around your workforce. And we have some ideas how to do that we will share with you. In terms of hiring, under Dutch law, we have two different types of contracts: indefinite contracts and fixed term contracts. With regard to fixed term contracts, we have the opportunity to agree upon a maximum of 36 months or a maximum of 3 fixed term contracts. So that means, for example, that you can offer an employee 3 contracts of 1 year, and after that, it turns into an indefinite contract. What we see a lot in practice in terms of hiring staff at the moment is that employers want to keep a certain flexibility by offering, at least to start with, a fixed term contract of 1 year, with the promise that after that they will offer an indefinite contract in order to make it more attractive for employees to agree with the initial fixed term contract of 1 year. But as an employer, you have the possibility to, think about what works best for you within this range of 36 months or 3 fixed term contracts. What we also see at the moment a lot is discussions around non-competition and non-solicitation clauses, especially with the tight labor market. We see a lot of companies trying to attract employees from their competitors to persuade them to come work for them. And what is always important to check in that regard is whether the employee you would like to hire already at the moment has a non-compete clause in their contract, which may prevent them from being able to enter into employment with your company. So it's worthwhile to check the current contract of the employee you want to hire, especially because as an prospective employer of that new employee, you may also be held liable by the previous employer of that employee if you hire that person anyway, knowing that they are actually bound by a non-competition clause. And especially at the moment with the great resignation going on, we see a lot more discussion about these non-compete clauses in employment contracts. There's always discussion around whether they are legally valid or not. There's always room for a discussion if the scope of the non-compete clause may not be too broad. So Even if the employee currently has a non-compete clause, there may also be arguments to say that it's either invalid or not applicable in the current situation. So that is definitely a topic that we see an increased importance in our practice at the moment. What we also see a lot is discussions around the trial period. Under Dutch law, it is allowed to include a trial period of 1 month in a fixed term contract that lasts 6 months or longer. And in an indefinite contract, you are able to include a trial period for 2 months. It is actually pretty standard that a trial period is included in an employment contract, but there are reasons to consider taking it out of your contract. What we see a lot at the moment in our practice is that employees accept a new job, and a week before the starting date, they call their new employer and say, yeah, sorry, I'm not going to join you. I found another offer, or they may not even explain themselves and just say, sorry, I'm not going to join. And then they can use the trial period in their employment contract to indeed say, I'm not going to start. Some employees do it differently and they start working, and after a few days, they say, I'm going to leave, I'm going to use my trial period and quit working. So if at the moment you are struggling to find new employees, this is of course very undesirable. If you finally found the right candidate and you're happy that you fulfilled the vacancy and you think that someone is going to start, and then a few days before they come in or a few days after, they already leave. This could be a reason to consider not including a trial period in your contract, which means that the employee is not allowed to terminate that contract using that trial period, which gives you a bit more certainty that they will actually start their employment with your company. The other side is, of course, that as an employer, you also lose that right. So if there's no trial period in the contract and the employee starts and you're not very happy, as an employer, you also no longer have the opportunity to terminate the contract, but you can compensate that by, for example, agreeing upon a fixed term contract, which at least gives you the certainty that the employment contract will end after the agreed upon period of time. So this is also something that we see more and more companies thinking about, okay, should we include it? Should we not include it? And that is something to think about if you are indeed struggling to find the right staff. Finally, in terms of hiring staff, there is also the possibility in fixed term contracts to agree upon the possibility to terminate it prematurely, so before the agreed upon period of time. This is after the trial period has lapsed, if it has been included in the contract. And for example, this means that if you have a contract for 12 months, the employee could give notice of termination after having worked for 4 months. That could still be a situation that you may want to avoid, because you may want the certainty that the person you are hiring is at least going to be there for the 12 months or longer that you need them to be there. If you don't want to give them the opportunity to leave before those 12 months, you could consider not including this possibility in the contract, which leads to the situation that the employee in principle should work during the full period of the contract. Of course, in practice, if the employee really wants to leave, even though it is not possible because that's not included in the contract, you never want to have someone on board that is really not motivated to work for your company. So if they really want to leave, I think ultimately you may need to let them go. But taking out this possibility to prematurely terminate the contract does provide you more certainty that the employee will have to stay during the period of the contract that you agreed upon. Then in terms of retention of staff, what we experience now a lot is employers asking us, how can we make sure that the people we have on board already, or the new hires, that we keep them, that they do not leave for the competitor and go find a new job. Especially in the post-COVID, current COVID situation, there are, of course, a lot of options you have as an employer, but also here, maintaining a certain amount of flexibility is important for the financial situation of your company. So what we often advise employers is to think about, instead of offering salary increases, for example, to think about offering discretionary bonuses. And the reason why we do so is that a salary increase is, of course, permanent. It keeps on going as long as the employee has been employed by the company, and is something that you cannot revoke or change as soon as it has been given. However, a discretionary bonus is, of course, a one-time bonus, which leaves you with more flexibility. And as long as you also communicate that it's discretionary, you also leave room for yourself to eventually decide that maybe because of the financial situation of the company, you unfortunately cannot grant them the bonus that you discussed. So this is one of the ways that you can try and retain staff, but also for yourself maintain a certain amount of flexibility around the terms and conditions that you're offering. Other options that we get a lot of questions about from employers are thinking about how to offer attractive employment conditions, which are not maybe related to salary, but to other employment terms, which is, of course, a hot topic at the moment, working from home partially or fully. We have been doing so, I think, for the last 2.5 years. And a lot of employees consider that a positive thing and would like to keep doing that. And we also see that in practice a lot, that employees switching jobs really ask their new employers how their policy is around working from home now and in the future. Also, flexibility in terms of working hours is something that has really changed in the working situation. Maybe start a bit later to avoid traffic, or go home a bit earlier to avoid the traffic is also something that is really important at the moment. And of course, as an employer, you can also think about offering a certain career perspective, training courses to employees, etc. So that is something that we see a lot now, where employers try to retain staff by offering these kinds of employment conditions. And one thing that is really important to keep in mind when thinking about these kind of employment terms and conditions is the equal treatment element of these employment terms and conditions. Because sometimes employers think about hiring a certain group of employees for a certain part of their company, or they just want to have a flexible pool for a fixed amount of time. And then they sometimes think about offering that group of employees other terms and conditions compared to their current employees. For example, especially in terms of the people they employ internationally and the people that work for the company locally. So maybe fully from the Netherlands compared to people working from abroad. And it is very important to keep in mind that, of course, you are not allowed as an employer to treat your employees differently in terms of offering them terms and conditions, such as salary, but also the amount of training that you offer them. And that's not only between men and women. Equal treatment is also an obligation in terms of employees who work on an indefinite or fixed term contract. So, for example, if you are now engaging a large group of flexible employees based on fixed term contracts, you cannot offer them other terms and conditions than the people who have an indefinite contract. And there's also not an option to treat people differently who work full-time or part-time. So this is something to keep in mind when thinking about retention of staff and the employment conditions that you would like to offer them to do so, to make sure that you do not violate any rules of equal treatment when doing so. Emmanuel, did you get any questions around this first topic?
No, Michelle, for now we have no questions.
Okay, good. Then I will continue with the next. So the second topic I wanted to share with you is a European directive that has entered into force around transparent and predictable working conditions. There are some changes coming up. Emmanuel, like you said, they indeed come into effect on the 1st of August this year. So it's a few months away still, but nevertheless, it's good to prepare yourself for these changes. The EU directive aims to provide employees more transparent and predictable working conditions. One of the items that is included and will change based on this directive is that employers have to provide employees mandatory training following from the law or a collective labor agreement free of charge. So they are no longer allowed to charge the employee with costs for training that follows from the law or a collective labor agreement. For these costs and these trainings, it's also no longer allowed to agree upon a study cost clause. So that is something that we also see a lot in practice. If the employer offers the employee a training, then they also agree upon some repayment obligations. So for example, if you leave within the first year after completing, you have to pay back 75% of the costs. And if you leave within 2 years, then half of it, etc. Such an agreement between the employer and employee is no longer allowed from the 1st of August if it's related to the mandatory training following from the law or collective labor agreement. At the same time, that also means that it is still allowed for other trainings that do not follow from the law or collective labor agreement. So it's not fully gone, but it is limited to training only that not follows from the law or collective labor agreement. Another change that follows from this European directive is that the prohibition to perform ancillary activities, so another job in addition to the job that you have with your employer, is no longer allowed. I think almost every employment contract that we see has a clause in it that says that the employee is not allowed, when they are employed with their current employer, to work somewhere else in addition to their job. This clause in the employment contract after the 1st of August is still allowed. So there is no need to change that clause in the contract. But when the employee requests permission to work somewhere else, at that moment, the employer should provide an objective ground why they refuse it. So the starting point is that the employee will have the opportunity to accept another job in addition to their current job. But the exception to the rule is that if the employer has an objective ground to refuse it, that's possible. So that is something to think about. Like I said, there is no need to change the current clause in the contract. The wording of it is not immediately something that is invalid. However, you need to be aware as an employer that if the employee invokes the clause and asks permission to work somewhere else, it will be very difficult from then on to refuse that. In addition, the directive provides the right for the employee to request a manner of work that provides them more predictable and certain employment conditions. What does that mean? It actually means that the employee can ask the employer if there is a different position in the company or a different working schedule that they can offer them that will provide more predictable and certain employment conditions. In some companies, employees work on a contract that is an on-call contract, so they hear a few days or hours in advance when they are required to work. And if there is no work, they will not be asked to come in, and also will not have a salary, of course. And the employee will now have a right to ask the employer if there is a way that he can perform the work that gives them more certainty and clarity around working hours and salary. The employer can refuse this request. And of course, if such a possibility is not available in the company, then the answer is simply no. There is no obligation for the employer to create such a position or such a working way. But the employee does have a right to ask for it if they want to. And the employer should take the request seriously and should try to make it work. But if it's not possible, there's always the opportunity to deny that request. And finally, the European directive also obliges the employer to provide more information about the terms and conditions of employment. That obligation currently already exists. It says so in our Dutch civil code that the employer should provide certain information about the terms and conditions. That can either be done in the employment contract, but it can also be done in the employment handbook, if that's applicable. And there are a few new items added to the list of information that the employer should provide. And these are, if there is a flexible place of work, so not the employee works in the office, but for example, the employee works partially in the office, partially from home, partially from abroad, that this should be clarified in the contract or the handbook. There is also an obligation to provide information about entitlement to paid leave, which in practice is often included in the employer's handbook, but it's not always in there. And after the 1st of August, it really needs to be in there. So it's no longer enough to refer to the Dutch law about this. You really need to actively inform the employee about that. You also need to inform the employee in light of the previous bullet point, whether they will have predictable working hours or not. And if that's not the case, you need to inform them what it will look like. And also the employer should inform the employee of the days and hours during which the work should be performed. Most employment contracts already include that information. We work from Monday to Friday, starting at 9 and ending at 5, for example. But if that's currently not in your contract, please be aware that as from the 1st of August, it should be in there or in your employee handbook. So to close off my presentation, this is, I think, also an important call to action for employers to check your current employment contracts and handbook to see if you still meet the new information obligation as of the 1st of August. And if not, there may be a reason to add certain information to either your employment contract or your handbook in order to be compliant.
Thank you, Michelle. Actually, there is one question on the 36-month period, and in general, with regards to the points explained. This is for employees on the books, but does it also apply to a ZZP'er who invoices monthly for their invoices or their services?
No, because self-employed persons do not fall under the employment contract regulations. So that's different. So the rules around the 36 months and 3 fixed-term contracts is based on employees working on the basis of an employment contract and not self-employed persons. Of course, for self-employed persons, I think in general the same principle applies. It also may be worth to agree upon a fixed services contract with the self-employed person to also have more flexibility around that cooperation as well.
And there's actually another ask for a question for confirmation. So from the 1st of August, you need to ask permission to work on various jobs. And this is not going for self-employed persons, of course, huh?
No, this is also a rule that applies to employees working on the basis of an employment contract and not for persons working as self-employed persons. The situation is actually quite different because I think for self-employed persons, you prefer them to have multiple companies that they provide services to in order to avoid it being considered an employment contract. And with regard to the permission, I think I maybe need to clarify that point a little bit. So most of the time, the clause in the employment contract states that the employee is not allowed without the prior permission of the employer to agree or accept an additional job. So that clause leads to the situation that if the employee does want to have an additional job, they have to go to the employer for approval. That remains the same, so you can still have that clause in your contract. The only thing that changes from the 1st of August is that it will be more difficult and maybe almost impossible to refuse that permission as an employer, whereas now you have more grounds to say, I will not give you that permission as an employer to accept another job.
Thank you, Michelle. We have no more questions at this point, actually.
Okay.
That's me. Shall I go ahead, Emmanuel? Okay. Hi, my name is Alain Camonier, and I'm going to talk to you about some European issues which apply at the moment already in the Netherlands and more or less in every European Union member state. We've had some quite strange years lately, and we simply forgot, or maybe I forgot, that in the last couple of years during COVID or just before, some major changes with respect to employment occurred in our environment. For example, Brexit, that was one thing. The other things are the Posting of Workers Directive, which has some new issues or issues since 2020, but were not too much executed because people were not moving in the European Union because of COVID, but the new rules are still there. Of course, we also have the Ukrainian war at the moment, which also brings us some new rules, legislation, or some things to think about with respect to employment. So I will take you to that, together with some insights we have in this situation after COVID. I mentioned the Brexit, so very quickly, Brexit has created changes, and talking about employment with respect to immigration. So you need to have working permits and residence permits, of course, for UK citizens, and vice versa if you go to the UK. With respect to employment rules, nothing has changed. And that means that in the agreement between the European Union and the UK, it is agreed upon that all employment conditions and all employment rules and legislation stay as is. So that is more or less clear. That's called a regression clause. Even GDPR stays as is at the moment. The only thing is that the UK will not follow new rules, will not follow European Court of Justice anymore. So gradually it will shift with respect to employment law from the European Union. But at the moment, you can still work as you did before. Maybe something which is good to know. Next slide, please, Michelle. One thing we see at the moment, which is an issue more than before, is people working in other countries, because we all understand and we all know that since COVID, people are working from home very easy. And that is what we all recognize, but we all also see that people are not working from home in one country, but their home might be in this picture, for example, the company is in the Netherlands on the left, and the home of the employee is in France, or it could be wherever, but across the border, and that we all think is, yeah, workable. That is what happened. People went home, used Zoom, used Teams, and worked, and in a lot of situations to the benefit of both parties, and everybody was happy. So to give you an example, what we have quite a lot in our practice, that people were hired in the Netherlands. In 2019, they started working in the Netherlands. Then COVID broke out in 2020. And in March or April, they went home. And at that moment, from that moment on, they worked in their home in France, in my example. That was a temporary situation, but hey, it's 2022. Everybody's still working from home. Everybody's still happy. It's going okay. So why should that person come to the Netherlands and work in the Netherlands and rent an expensive apartment in Amsterdam? Next slide, please. That is something to take into consideration. And from an employment law perspective, I need to refer to a European Union regulation, European Committee regulation. It's called Rome 1, Article 8. And in short, it says the following. And by the way, I have more sheets than I will talk to, simply because I have limited time, but you will be shared the sheets so you can read it out yourself. The Rome 1 regulation simply says when an employee habitually, so it's normally working in a country, at that stage, the employment law of that country is applicable to the employment contract. So what does that mean? If you have employee number 1, so yellow is one country, green is another country, and the dotted line is the border. If you work in the yellow country, say the Netherlands, and every now and then you go to France, which is green, in my example, at that stage you normally work in the Netherlands, so Dutch law is applicable. So if you have your employment contract, Dutch law applies to this contract, that's okay. Employee 3 is what we see a lot in these days. So those were the people who used to be employee 1, so working in the Netherlands, and then every now and then going abroad. But since 2020, they're working from home in France, in my example, and they are still working from home. And COVID is gone. It's not gone, as we all know, but the COVID restrictions are gone. So that means if that employee stays working in France, so we still talk about employee number 3, at that stage, this employee normally is working in France. And that means that the EC regulation Rome 1 says, normally working in France from home, which means French law will be applicable. And then the employer says, yeah, but we have an employment contract, and the employment contract was started in 2019, and it says Dutch law is applicable. So all Dutch rules apply to this employment contract. Now, it's very simple. Rome 1 says French law is applicable, and that overrules what is in the employment contract. So whether you like it or not, at that stage, the employee number 3 can say French law applies to the situation, and we should follow French law. You should pay me towards French law, all the French rules with respect to illnesses, with respect to holidays, with respect to dismissals, etc., is applicable. So I don't care whether in the contract it says Dutch law. This is the situation. Please be aware that this is happening at the moment. So when it's clear that someone is working abroad based on contract post-COVID, make sure that you change, you amend your contract simply because Rome 1 regulation makes that the law of the foreign country overrules your employment contract. And you don't know what it is. If you don't put it in a contract, you don't know what it is, except for the situation where something goes wrong. When does something go wrong? In our practice, mostly when someone is going to be fired or when someone is going to get ill. Those are the most of the time the big issues. But we can also talk about bonuses or holidays, etc. In addition to this, but maybe most of you already know this, also be aware if employee 3 situation happens, that can or that will also have its effects on wage tax obligations and also on social security obligations, because that will also be transferred to France in this situation. And to make it even more complicated, be aware if someone works in a non-EU country and stays at home, and it's not easy for such a person to come to the Netherlands anymore because of the immigration restrictions. Last but not least, if employee 3 is having the benefits of a 30% tax rule, at that stage also that is it cannot be used anymore, and that means that there will be a claim from the tax authorities if you still use that 30% tax rule in spite of the fact that that employee is working abroad. Next slide, please, Michelle. And yeah, this is another slide, because I said I won't use every slide. Yeah. So that was one thing we experienced. The other thing is the Posting of Workers Directive. That means that we already have since 1996 a Posting of Workers Directive, which means that when someone is being sent to work from one European Union country to the other by its employer, then you should take good notice of the Posting of Workers Directive. That is not new, it already exists, but there are some new rules which were executed during COVID. Michelle, next slide, please. If we I've mentioned, I've put this picture in my presentation, and this picture shows how many people are being posted from one country to the other country. This is a 2017 sheet, so it will be a little bit different after COVID. But if you can see, there are a lot of European people coming from other countries to work in European Union member states. Netherlands is in the middle somewhere. And if you see that we had in 2017 90,000 people working for one or more periods from the European Union country in another. Those are the people coming for a temporary period. So they're not people working for not the expats. They are working normally in the Netherlands, but we're talking about posting of workers. But it is really a European issue, and as you can see in the Western European countries, a lot of people coming from Eastern Europe. I think that will not be a big surprise. Next slide, please. What is then a posted worker? To give you this picture again, we have an employer in the Netherlands, and that employer has an employee. That employee works in the Netherlands, lives in the Netherlands, and is being sent to work abroad in this situation in France. The employment contract still exists, so it's not that we have a French employment contract if you send someone abroad governing the employment contract, so still under the Dutch contract, but for 3 months or 4 months, this person works in France under the Dutch employment contract, and then is being confronted with also French law on top of the Dutch employment contracts. And that is the Posting of Workers Directive. Next slide, please. And this is important because per July 30th, 2020, so in the middle of COVID, in the Netherlands, but to to be honest, in every European Union member state. In the Netherlands, it was the new directive was implemented, and that directive, it says very simple, when you post someone, so if you send someone, my example, from the Netherlands to France, at that stage, within the first 12 months, you can keep someone employed under the normal Dutch employment conditions in France. However, you should take into consideration the minimum restrictions of France. So is that a big thing? No, not so much. That means that within the first 12 months, you should use, on top of the Dutch employment contract, minimum pay in France, minimum holidays in France, minimum health and safety precautions in France. So nothing strange there. And if the temporary posting exceeds 12 months, you can get in France an extra 6 months if you go to the authorities. However, next slide, please. When you, sorry, one slide back, sorry. When you extend this 12-month period or 18-month period, at that stage, so after 1.5 years, always, and after 1 year in most of the times, you should use all the same employment conditions of French people in comparable functions. So if you send an employee working in France under a Dutch employment contract as on a more or less short-term assignment or on an assignment, Dutch law still exists. That is possible for 12, 18 months without any problem. But if those 12 or 18 months are being extended, you should have a look at what is a French person in that position. So in short, a colleague, what is a colleague earning, and that should also be paid to this employee, whatever is in the Dutch contract. And you can imagine that maybe from France to the Netherlands is not a big issue. If you get someone from Poland to the Netherlands, that is a bigger issue. That is new since July 30th, 2020. And that is also being looked at by the various labor inspections. So be aware of that. A big change after 12, 18 months. Next slide, please. Another new issue is also based on the Posting of Workers Directive, the enforcement. And that means that since 1 March 2020, so just before COVID, but still, we have the obligation that when you are sending someone from one European Union country to the other, that you should notify the authorities, which means that if you send an employee from France to the Netherlands, at that stage, this employee should be notified to the authorities in the Netherlands by means, the website is mentioned here on postedworkers.nl online melden. And every employee who will be working in the Netherlands since March 2020 should be registered with the authorities. If you don't do that, that means that the employer, the foreign employer, can get a fine of maximum of 4,500 euros per employee who is not registered, and the employer in the Netherlands, so the company where the employee is working, can be fined for 1,500 per employee who is not registered. This is more or less a big thing. Be aware that this exists, and it not only exists in the Netherlands, it exists in every European Union member state. So you should register all your employees working temporarily in another member state on beforehand with the authorities of that country. Every country has different rules. That means in the Netherlands, you have to go to this website In Italy, you should provide authorities with all kinds of documents, salary slips, employment contracts, etc., in Italian language, which means that it should be translated with you. In other countries, they have other rules and obligations. Also, the penalties are different in each country, but this rule exists everywhere because the European Committee wants to know who is working where. And the reason behind it is protection of their own labor markets. Then maybe someone says, yeah, but it's a free labor market. That is the whole idea of the European Union. Yes, but not quite so much. So since March 1, be aware there's a notification obligation and it can cost you money. Are penalties being sent out to employers? The answer is yes. We have clients who got in Austria, for example, for 20 employees penalties, so 80,000 euros, and that is not a good thing if you add that to your expenses anyway. Be aware. Next slide, please. Last topic before the end, very quickly, is the recruiting and hiring of Ukrainian refugees. A big thing at the moment. Next slide, please. The European Commission understands that this is a big issue. So there is a directive applicable, you can read it out if you like, which says that every European Union member state should allow people coming from the Ukraine to have not only work, but also schooling, also housing, etc., when fleeing from the Ukraine. And next slide, please. Because of the European Commission said so, or maybe not only because, but because of that, in line with the directive, we have per April 1st, 2022, the possibility to employ Ukrainian employees without having a working permit. By the way, there's a retrospective effect to March 4. So if you hired someone before, you were not allowed, but now that's being repaired. So that's good. It's only for employees. So not talking about contractors, ZZP'ers in the Netherlands, and so they can work. So that may be a good thing. Next slide, please. But be aware that Ukrainian employees, Ukrainian refugees are not normal employees. So please do not think that you can use Ukrainian employees to fill up a gap of employees you have, or that you can say we can be competitive. The discussions I had with employers is that hiring Ukrainian employees is more ESG, so then it is HR. Be aware that if you hire a Ukrainian refugee, and most of them are women, by the way, because most men are fighting in Ukraine, Dutch law is fully applicable. So if you hire someone, if someone gets ill, you should take into consideration all the rules and obligations with respect to ill employees, pay out salary during illness. You can't simply terminate an employment contract if it doesn't work out. And we are working here with people who have traumas, who want to be reunited with their families. We don't know where their families are, so maybe their families are in Romania or in another part of the Netherlands. They have often children who also are traumatized. So what happens if they can't come to work because of the trauma of one of their children? How are you dealing with that? If you want to do that because of helping them, please do what you have to do, but don't do that only from a normal HR perspective, that is not working. I want to refer you to Vluchtelingenwerk Nederland, if you are thinking of that. For a small and medium-sized employers in the Netherlands, it's good to contact the employer service point in your municipality. For Amsterdam, I mentioned it here, but every district in the Netherlands has a service point who is working with that. If you're a large national employer, please go to Vluchtelingenwerk Nederland, and I've mentioned two people who you can contact. And what you should not do, that's my advice, do not work with non-certified agencies. There are at the moment a lot of agencies popping up, and those agencies are not certified, so not certified by the SMA in the Netherlands and not certified by the ABU. So I'm not talking about the Randstad and the manpowers of this world, but to be honest, agencies who think they can combine employers and Ukrainian refugees with a intention to make profit, please don't go that route. If you want to read more about it, please read my sheets after this sheet. But again, if you want to help Ukrainian employees and you do want to do that with work, please do so, but do it in a good manner, and be aware that there are some problems, but there are people who are really doing good work for this and take good care of that. With this last remark, I would like to end my presentation. I give the floor to you, Emmanuel.
Thank you, Alain. Yes, I concur with the ABU certification and the fact that it's necessary to, as an employer, to make sure that you work with a reputable agency, of course. Not only in the case of those Ukrainian refugees, but in general. ABU certification means something. We know about it here at Untouchables. So thank you. I simply wanted to go back a couple of things. So the work permit for Ukrainian refugees, it's indeed only for a salaried work. And the permit that is being given now is for a duration of 1 year, right?
Right.
Okay. And because we've had a lot of questions about that from actually some of our clients. We've employed Ukrainians in Ukraine doing business there as the local ZZ pair. Those Ukrainians, when they arrive in the Netherlands, are not allowed to register themselves as a ZZ pair, as an independent contractor, right?
Yes.
Yeah. Thank you for that. We had actually a couple of questions, but I think you've covered them in your previous slides regarding the amount of time that you could stay in a foreign country before the law takes over. So how long do you need to live in the foreign country before that the law takes over? So it's 12 months, right?
Yes, it depends whether you speak, but it's going to be legal. When you talk about the Posting of Workers Directive, yes, that's correct. When someone is working abroad from home, that's of course not a posting. Then be aware that after also 1 year, also likely the law of the country where you work is taking over, but then also fully. So okay. To say 12 months, always a thing to check.
And would that apply if the person lives only partially in that other country? How does it work?
The partially thing is also a big thing if you work for 25% abroad, and that is your residence country. At that stage, Social Security takes over. That's an issue. We always look in the law, where do you normally work? So that is not only counting days, that is also where is your office, where do you sign contracts, for example, do you have people helping you, and in which country is that, for example, secretaries or whatever. So it's not the same as in tax law, where you simply say 183 days, yes or no. Yeah. It is really what can be considered normally working.
If I may add a final comment to that, this of course happened quite a lot due to COVID. Yeah. We already have seen some case law where there is a discussion about which law is applicable. And if it's clear that the employee was only allowed to work from home because of COVID, and that was the only reason why, then judges may still rule that the applicable law has not changed, because it is clear that the only reason the employee worked from home was because of COVID and that they were not able to travel. So if that is the situation, then it's also different from the general situation where you work temporarily in another country.
Yeah, correct. And if you look at this, only COVID, with respect to Germany and Belgium, tax authorities and the UWV, they said you can use this exemption until July 1st, 2022. So you have still some months and you can still use the Dutch wage taxes, Dutch social security, and then also Dutch employment law. But if after that date you are still allowing people to work from home without COVID restrictions, we can't say anymore this is only because of COVID. So then you will be normally working abroad.
Yeah. And you will be considered as a posted worker, basically.
No, not a posted worker. You are a worker abroad. Posted means that you are there on a temporary basis, and people working abroad from home are there on a normal basis. So it's even gets farther than that.
Yeah, it will still make some evolution there in the months post July, I imagine. Particularly if companies still apply the hybrid work situation where people still can work from home. We'll probably have to come up with new solutions there.
Yeah, this is an issue. And by the way, there is also some new law coming up. The SER, the Social Economic Council, came also with an advice where that the people can work hybrid from home, but this issue was not touched. The fact that we have issues, people working internationally from home, that is an issue. There was only one sentence in the report where it says, countries should make additional agreements on that. What kind of agreements? But we all have to deal with that without having extra legislation. So be aware, Social Security tax that is for Belgium and the Netherlands, so Belgium and Germany, there we have an issue after July 1st. For all other countries, it's already the question, when is it temporary, or when was it temporary because of COVID, and when will it be normal?
Yeah, clearly. Well, we've just reached the mark of 11:02. So thank you. It was beautiful. Thank you for actually trying to probe everything, all that information within the time frame that we had. Of course, for all of you who are listening to us and who've been viewing the presentation, thank you for joining us. Don't hesitate to reach out to Michel or Alain. The presentation, as always, will be sent to you in the next few days. To all of you who registered and attended the presentation today. So you will have the copy of the presentation and Alain and Michel's contact information. And we hope to see you soon again for the next expert talk, and maybe for our HR event in June. But more info will be shared soon from our marketing department. Alain and Michel, a sincere thanks for joining us. It was a pleasure as always. And see you soon as well.
Thank you. Bye-bye.
Bye. Bye.